Very, very good. So dear participants, dear friends, it's a pleasure and honor to organize a very specific activity on trade secrets. So how do trade secrets really matter? And when does trade secret regulation do trade secret measures become a trade restriction? This is something that is quite crucial for us. We need to understand if trade secret regulation or non-regulation or wrong regulation may lead to restrictions and therefore to problems in the methodology we are developing so that we establish a digital trade index that covers the whole world, including the USA, most countries of Latin America, countries in Europe, Asia, Africa, Arab countries, and so on. So as such, in order to discuss this super important question that we are covering in our methodology, but that we want to revise in our methodology, the one that Martina Ferracane, as leader of this EUI, Bocconi, Hertie, London School of Economics plus project, including the commissions or the regional commissions of the United Nations and the research centers in Brussels. In order to adjust this methodology, we are happy to have with us to advise us, but also to guide us through a presentation, Professor Sharon Sandeen. Professor Sharon Sandeen is one of the world's most known and best experts in trade secrets. So for us, it's really a pleasure and honor to have her today. She is Professor of Intellectual Property Law at Hamline University in St. Paul in the US. She is also director of the IP Institute there, and her reputation in the field of trade secrets, her expertise is really called for everywhere. So we are super honored that Sharon has accepted to be with us, and also to be with us with a delegation of those who study with her. So we are super. We will greet them as well in our small international family. Sharon, the floor is yours for this first half an hour. And then we will have a debate jointly with all the participants.
Thank you so much. I'm really happy to be here, and I'm going to show my PowerPoints next and go from there. You know, one reason I'm happy to be here is to be able to think about trade secrets in the context of digital trade is very important, and I hope to demonstrate that as I go through my slides. Now, in preparation for this talk, I decided to look at what some of the organizations involved in international trade and development are saying about digital trade. And I have on the screen here whoops, I gotta go back. Some language from the United States Trade Representative on the importance of digital trade. And I underlined some language that I think is important for what I'm going to say in a little bit. It defines digital trade as a broad concept, capturing not just the sale of consumer products on the internet and the supply of online services, but also data flows that enable, and I put in brackets, various beneficial things like global value chains, services that enable smart manufacturing, and myriad other platforms and applications, which of course, I also put this in brackets. It would include the Internet of Things, and it also includes artificial intelligence devices that are being developed. And so for trade secret purposes, I think the most important thing to focus on is the reference to the importance of data flows in digital trade. I also read a report from the OECD on the impact of digitalization on trade. And again, once again, the emphasis here is not just on trade in goods and services, but also in the flow of data and ideas. And in this case, emphasizing how the digital trade helps to diffuse ideas and technologies. And of course, we know that ideas and information is necessary in order to foster innovation and creativity. So the translation of all of this, not just these two things, but other references to digital trade, are that data flows are good. Data can increase knowledge diffusion and skill acquisition. And this is, knowledge diffusion and skill acquisition across borders throughout society. It spurs creativity and innovation. Data allows more people and companies to participate in the global economy. In theory, at least, it can lead to greater efficiencies. An example would be on-demand manufacturing and global value chains. And also data is what a lot of people recognize fuels is what is the fuel of a lot of artificial intelligence systems. But what I found interesting and what I think it's important to recognize in the lead up to my discussion of the details of trade secret law is that the very same organizations that, the USTR, the OECD, and other organizations that have been pushing for an examination of digital trade and a reduction in restrictions on digital trade are also the same exact organizations that in recent years have been pushing for heightened trade secret protection. And there's an obvious tension between trade secret rights and data flows. I think it's interesting. I am a lover of history, and I like to think about these issues in historical context. And just remember, there was a time in our history that, during the Enlightenment, where we realized that the acquisition of knowledge and information and the diffusion of knowledge and information were very important. And we thought that it would lead to greater innovation, creativity, better, prospects for citizens in countries, better trade, so forth and so on. And we invested a lot of time, trouble, and energy in knowledge diffusion. We built universities, we built libraries. And what happened was, of course, in between where we are now and then, there was kind of what I call the rise of IP, where we recognized the need to protect certain types of information, to encourage the creation of more of it. And to do so, we created rights to exclude. And then here we are now talking about digital trade, which in many respects is similar to what was discussed during the Enlightenment, that knowledge diffusion is good, that we need to encourage the diffusion of more information and knowledge. We need to break down barriers to digital trade. So we have these competing interests. And I think the important thing to understand, and what I will be talking about most now, is how do we reconcile these competing interests? And I've categorized my thinking into three topics that I've labeled: precision, limitations, and process. So with respect to precision, I think it's important when we think about digital trade and how trade secret law might restrict digital trade, is to understand the limited scope of trade secret law and to apply trade secret law correctly. One of the things I've been noticing recently, well, not recently, but I've been writing about recently, is the fact that a lot of businesses and policymakers equate secrecy with trade secrecy. So you ask a business, if we were to call up a business today and say, hey, do you have any trade secrets? They're likely to say that they do, because they believe that they have information at the company that is valuable to them and that they keep secret. And I have no doubt that that is true in many instances. The problem is that what a business person or even a common, the common person on the street would think is a trade secret is not a trade secret under law. Law requires that in order for information to be a trade secret, it has to meet three very specific requirements. And let me just pause here and say, as I'm talking, of course, I'm focusing on US law as expressed in the Uniform Trade Secrets Act. But I'm confident that this is also relevant outside of the United States because, as many of you may know, the Uniform Trade Secrets Act is the model for international trade secret protection. It was used and incorporated in Article 39 of the WTO TRIPS agreement, and it also served as the basis for the EU Trade Secret Directive. Since the WTO TRIPS agreement was entered into in 1995, it's also been used by the United States to encourage many other countries, notably Canada, Japan, Mexico, and China even, to adopt a similar framework. So I would say that although some countries of the world have not yet adopted the Uniform Trade Secrets Act standard of trade secrecy, it is largely the international norm, and so it is worth paying attention to it. Now, with regard to the definition of a trade secret under the UTSA and also under the TRIPS agreement, there are three requirements, and secrecy is only one. The other two is that the information has to have commercial value. In the United States, we call it independent economic value, and it has to be of value to others. And then the information also has to be subject to reasonable efforts to maintain secrecy. So when we know that definition exists, we can see that secrecy alone is not enough to protect information. And I should also point out, this is something that varies from in other countries, but in the United States, at least, sweat of the brow doesn't count. In other words, just because you gather and collect information doesn't mean that it's protected by trade secret law. The other three requirements, secrecy, economic value, and reasonable efforts, have to be there. So one answer to digital trade and the restrictions is just to apply trade secret law correctly, and that should reduce the amount of information that is not available for digital trade. The second category is limitations. And one of the things to note here is that there are laws besides trade secret laws that protect data and information. And if we want to think about improving digital trade, we have to think about those laws too. In the United States, the drafters of the Uniform Trade Secrets Act did think about this when they drafted that act in the 1970s. And what they did as a result of thinking about it is they created a provision of the law called Section 7, which basically precludes any causes of action, tort claims, or equitable claims other than a trade secret misappropriation claim for what they called competitively significant information. And so in the United States, if you want to sue for the wrongful use or disclosure of competitively significant information, you only have two options. You can either bring a trade secret misappropriation claim if the information qualifies as a trade secret, or you can bring a breach of contract claim if there happens to be a valid and enforceable contract associated with that information. And those are the only two causes of action. Now, this concept, what I would call Section 7 concept, has not been adopted in other countries that I am aware of. For instance, it's not part of the EU Trade Secret Directive. So it may be that in the various EU countries that are subject to the EU Trade Secret Directive, that there are other laws and legal principles that would serve to protect various bodies of information. And so those laws and legal principles have to be looked at to assess whether or not they also provide, prevent digital trade in the subject information. With respect to the third category, this is process. And what I want to talk about here is the circumstances, the factual circumstances in which trade secret issues arise. And I'm in the process of working on a paper regarding this, which I'm calling mapping secrecy. And what I'm trying to do is find all the places in law where the issue of secrecy or assertions of secrecy arise, so that I can determine, what the applicable laws are and what processes exist in order to test the claims of secrecy. One of the places where this comes up a lot is in the regulatory context. And what's interesting about this is historically, trade secret law was created at common law in England and then transported to the United States. And there's a big tort claim or misappropriation claim associated with it. When issues of secrecy or trade secrecy come up outside of the litigation context, typically we're not talking about the wrongful acquisition, disclosure, or use of information. What we're talking about is information that is voluntarily or because of some regulatory requirement provided to a government agency, for instance. And the question is whether that information should be shared with others. So misappropriation, which is a limitation on the scope of trade secret protection, if you really think of it, really doesn't come up much. And the important thing then becomes whether or not the information is actually a trade secret. And the problem we have, and I can only speak directly with regard to the United States, is that the problem we have is that we don't have good processes for testing the validity of the trade secret claims. So when a entity says to a government agency, I don't want to give you this information because it's a trade secret, there's no ready and easy way to test whether it actually is a trade secret according to the definition of a trade secret. So I happen to believe that we need better processes to test claims of trade secrecy early, because if information is not a trade secret, then that would reduce the ability to keep that information from being part of digital trade. And related to that, we have to recognize that information sharing or diffusion is not the same as disclosure. So it's possible in many contexts. In fact, one of the underlying theories of trade secret law is that it facilitates information sharing and diffusions. But the idea is you can share information in certain settings if there's an obligation of confidentiality without the trade secret rights being lost. And that's something that I think we need to take more advantage of if we're trying to enhance digital trade. So I will end with some final thoughts that is kind of a summary of what I've already said, but leading to my final point, which I think is a harbinger for the future in terms of what we need to think about. Okay, so not all data are trade secrets, but much of it is kept secret or confidential. So the company that says we have a trade secret, a lot of times, as I mentioned before, all they really have is secret information. And it may be that it's not a trade secret because other people know it or use it in their own business and keep it secret, but none of these other companies know that it's actually written in a book somewhere on a shelf, which from a trade secret point of view would make it not a trade secret. A lot of data are collected from public sources. And I think this is important from a taxpayer's point of view and a public interest point of view, which is to what extent are we going to protect data and information and restrict trade in it when the information started came from public sources and was just collected by the company who now wants to restrict its sharing and diffusion. So an example that exists in the United States is we pay for counties to keep records of real property ownership, and that information is readily available to any company who wants to collect that information, create a database of it. And they do that regularly. That's why people get calls about selling their property and so forth and so on. So to what extent should we protect information that, originated from these sorts of taxpayer funded sources? Related to that is the public obviously has an interest in data that is necessary to facilitate free trade and greater competition. I think this is important, particularly important in the so-called information age and with the rise of AI. If data is the underlying fuel of artificial intelligence, and that's needed then that data is needed for there to be competition. And so we need to really think about how we're going to facilitate greater trade and freer competition by facilitating the sharing of this sort of critical data. Related to that, of course, is the data also needs to be accurate and reliable. This is something I don't think we've been focusing enough on. In my opinion, I think we should facilitate the sharing of information and put more of an onus on companies collecting this information to make sure it's accurate and reliable. That might be a better use of our time and energy. And then the final point is we need to think about, and because of all these points, we have to think about how we encourage the sharing and improvement of secret data. And here I have secret in quotes because what I'm referring to here is not trade secret information, although that might be part of what we want to do. But I'm talking about the sorts of information that companies and businesses claim is secret information, but it's not really trade secret information. That information, I can understand why, particularly if they collected it and spent money to do so, they may not want to share it. But it seems to me that it's inefficient in many situations not for us to require sharing. And the example I give is, if anybody has been to San Francisco recently, Waymo has cars that drive around San Francisco constantly taking photos of the streets, doing whatever they're doing in order to get ready for some sort of autonomous vehicle system. And it would be, I don't know, perhaps a burden, I think, to have multiple companies driving these cars around taking pictures. Wouldn't it make more sense if we required those companies to share that information and to work together to make sure the information is accurate, so that when the autonomous vehicles or the driver-assisted vehicles finally hit the road in a mass way, that the public is protected because we can rely on the information that was collected to be accurate. So I will stop there, and I look forward to the conversation about the issues I've brought up. I don't know if there's any.
I'm muted. Thank you so
Okay.
much for this really splendid presentation that really introduces the debate. I would wish to see if there are questions from our audience and or from Martina. So audience first and then Martina. From the audience? Professor Galliani, I saw you raised your hand. No, not now? Okay, fine.
No, I found it very interesting, of course, but for the time being, I don't have any comment.
Okay. So, Martina, if I may raise a question to you, how does this affect our methodology, and what should we ask or see with Sharon on how to restructure some points?
Yeah, I was thinking about this while you were going through your presentation, and yeah, I have several questions because this is something new for us, and so far we only had included the issue of forced disclosure of trade secrets as a problem for digital trade. And actually, on this, I had a question for you because. For now, we have this entry. Like we consider the only restriction we have is the forced disclosure of a trade secret, and actually in general, when it comes to WTO also negotiations, there is also just the reference to source code, forced disclosure to source code, and what we are seeing coming up more and more are some exceptions to this. So countries are committing to refrain from asking access to trade secrets unless, except in certain circumstances. And now the EU is making this list quite long, and with the new proposals also of the DSA and the DMA, they are adding competition law as one of the reasons why there should be this access. They're adding essential security interests and also IP infringements issues. So, like, I'm wondering, what do you think? You think this is reasonable? Because in our project, we are trying to identify some sort of best practice. There are different perspectives, and it's really hard to agree. But we would like to find something that we, at least as a group, consider a best practice in terms of a measure that respects the priorities of the governments, but also respects the rights of companies to do business. And when it comes to digital companies, trade secrets often are then their main asset, really. So I wonder, yeah, what is your view on this?
Well, maybe a helpful way to think about it is we have to take information, we have to put it into buckets, right? And so, and software is a really good example of you know, and source code is a good example of a body of information, which really is comprised of different levels of protection. You know, some of it is not, so you have some of it which is not protected by IP. It's not protected by copyright. It's not protected by patent, not protected by trade secret. But it's kept secret, you know? And so I think the challenge here is to figure, so we've made policy decisions. And of course, in the IP sphere, we're trying to define the edges of protection, and it's a continual battle. IP owners want more, and you know, people who are interested more in information diffusion want less, and it's this constant battle. And so we've done that. And I can say with confidence that certain bodies of information, including all these databases and source code, are not protected by IP. And we made those policy choices. The problem is companies can still protect things, to engage in self-help to protect that information. And so this is, I see as a challenge, a real challenge going forward in the information age, is to figure out what to do with that. Now, anytime a government says, thou shalt disclose this information, the response is, well, it's my information, it's my IP, it's my trade secrets, you can't do that. And in the United States, when that happens, the companies will say, and in fact, if you do that, government, I can sue you under the US Constitution for what's called the takings claim, and you're going to owe me a bunch of money. And so what happens is there's a restriction then, a lockdown of information just because of that. I should also add, in the United States, there's a federal law where federal employees can go to federal prison for disclosing information that's a quote unquote trade secret. So there's a resistance for government officials, kind of a built-in resistance for government officials to, require a disclosure of information that's not protected by intellectual property law. And so this is a problem. I think that's a central problem that this digital trade initiative faces with respect to information in the form of databases or source code or whatever other form it takes.
Just a follow up on this, if I may, because I don't really know usually what governments are doing and what is the best practice, but what we could consider, I'm thinking for our methodology, is that if there are these exceptions, because they seem to be pretty important for government, we should look into the law at whether there are appropriate safeguards so that this information is then not disclosed. I think that's very hard in practice to implement, but at least already having this in the law might be a kind of protection for companies in a way. Could be a kind of compromise. So.
Yeah, one thing that comes to mind along those lines, of course, there's two parts to Article 39, the TRIPS agreement, that are relevant here. One is Article 39.2, which is the provision regarding trade secret protection. But the other is Article 39.3, which is the provision regarding undisclosed information. Now, that's submitted in the regulatory context. And of course, that provision only applies to certain types of information. But if you followed what happened since the TRIPS agreement, in a lot of US free trade agreements, that particular protection for what we call data exclusivity protection has been expanded to include other types of information and to be longer. And what's interesting about 39.3 to me is the information it's the type of information that wouldn't be a trade secret. Because if it were a trade secret, it's protected by 39.2. So chances are it's not a trade secret, or there's aspects of it that are not a trade secret, which is why this push for data exclusivity is there. But there might be something, even though I'm generally against the ratcheting up of information, particularly information that is not otherwise protected by IP. I think the whole reason we have IP protection is to define the dividing line between what we want to protect and exclude from use and disclosure and so forth, and what we want to let free because we value information diffusion and knowledge diffusion. So even though I'm not in favor of ratcheting up laws for that, you could see potentially some sort of trade-off where there's an offer by a government entity to provide some sort of data exclusivity or something in order to encourage, for a short term, to encourage disclosure in the longer term. That's just an idea.
Excellent. That could be an idea which is a bit complex for us to, let's say, to take into consideration, but that is really a track for us. Martina and others, what do you think we should do at this stage? Can you hear me?
Yeah, for me, like, yeah, I think these I have to digest and process this information. I think it's like there's valuable information to update the methodology based on what we discussed.
Yeah, in this very sense, Martina, we can support, assist by all means, being more from the IP group to really help and support them at the stage, without any problem. Any question from the group, from the group of the researchers or from the participants brought by Sharon to Professor Sandeen? We still have a bit of time free. So
I have I want to tell a story. I don't know if everybody knows this because I recently wrote a paper on trade secret law, and I wrote this paper with Tanya Oppling, and we did 2 case studies. One was involving the credit scoring industry, and the other was the autonomous vehicle industry. And the reason why we wrote this paper is, I can only speak for myself, but I was just frustrated in the discourse, which was an assumption that, anything related to autonomous vehicles or any sort of AI, any sort of data related to that was a trade secret. Kind of well, of course it's a trade secret. We're a big company. We're doing, credit scoring or autonomous vehicles, and so of course it's a trade secret, and we get to protect it, and other people can't use it, and so forth and so on. And so we decided to look into that, because when you start to look into the specifics of those industries, you start to see, once again, that a lot of the information they rely upon is public information. And just to give you an example, all the information I have about myself, about where I've worked, what credit cards I have, how much I owe, et cetera, that's not a trade secret. The fact that a company collects that information and might use it to create, a credit score for me doesn't make that information a trade secret, because I know it. And so it's not secret in that sense. And so there's a lot of issues related to that. But what was interesting, and this is where I think it's just an example that struck me when thinking about digital trade. One of the critical things that happen in the development of autonomous vehicle technology concerned the ability to start matching what a camera on a vehicle was seeing with like what it was. And they basically had to train the machines to, when they saw a picture of something, to know it was like a cow or a dog or a cat or a person. And the way they did that is they had to code photographs. And there was a scientist, and I'm not going to remember her name, who started having graduate students look at photos and code what the photos showed. And she calculated it was going to take decades or hundreds of years to code enough photos. But what happened is she found a database that Amazon had created that already had this. And they were able to gain access to it and use it to start training the machine. So the point is that it was the sharing of this database that allowed the advance in autonomous vehicle technology and development, rather than the lockdown of it. And this is what we have to recognize. Now, it also is very important when you think about it that that database be very accurate, because if the photo is a dog and somebody says it's a human or vice versa, there's going to be consequences in terms of how the AI system works. So I think there's a lot of reasons why businesses and governments should want to encourage the sharing of information and freer trade in information, for the same reasons why we want free trade generally. It encourages innovation and creativity to have that freedom. But the initial thinking often in new technological developments is to want to lock down everything and keep it secret. And somehow we have to, overcome that and demonstrate the benefits of, once again, of information diffusion and the sharing of information.
Yeah, this is quite important. Any other question from the audience? I know the aspect of trade secrets is one of the aspects in the intellectual property law family, which has, let's say, a lot of areas of technicalities if we want to handle well, because precisely for the reasons mentioned by Professor Sandeen, the national legislations differ largely, the approaches of countries to it, and mixing concepts in laws are really problematic. So this is really a very problematic point in our study, and this is why it's so important that you've been with us today to guide us. No additional question from anyone in the audience?
Alejandro has a question.
Yes. Alejandro, please.
Yes. Well, thank you for this lecture, Professor Sandeen. And I was thinking about whether we could consider scoring trade secrets in our methodology, taking or seeing whether it is similar to an international standard like the one you mentioned from the US, I don't know. I was also trying to see a linking or to see a connection with our previous webinar, where we saw that one of the main problems with patents was the enforcement. So I was thinking that maybe trying to measure or to score the enforcement of trade secrets in a way that is according to or similar to an international standard would be great for us. But Professor Sandeen, maybe you can give us your impressions about your opinion or your opinion about how to enforce trade secrets in a proper manner. That would be my question, please.
Yeah, thank you for that question. So a few years ago, I think it was 2014 or 2015, OECD did a study and came up with a trade secret index, and they did do scoring of the laws of various countries related to what they thought were critical aspects of trade secret protection. I don't know if that study's been updated since, for instance, the EU Trade Secret Directive was adopted, but that might provide you with some guidance. But yes, enforcement is a problem with and particularly the international enforcement of trade secret claims is an issue that some people would say there's an inconsistency in enforcement, even to the point where if somebody gets sued in the United States for behavior outside of the United States and goes to enforce it in another country, that judgment is not respected. Part of the problem is that there could be a difference of opinion about whether or not the information is a trade secret or not, which might, from a factual point of view, might lead to different judgments in different countries. But that report I mentioned might serve as some information for you because somebody already did that.
Thank you very much.
Yeah, which is a very helpful text. Okay, perhaps we could work on this. I would wish to give the floor first to Ingo, who has asked for it. Ingo, please. Ingo?
Laurent, and
Yes.
big thank you to Professor Sandeen. I think my question is a twist on Alejandro's about implementation. So look, there are sins of commission and sins of omission, right? And so sins of commission mean, one problem Martina's team has to solve is what are all of these measures sort of that, infringe upon trade secret holders' rights. And, that is that discussion, whether the list of exceptions is too narrow or too broad and what have you. But if I understood you correctly, then probably the problem is somewhere else. It is that there are huge troughs of data out there that are actually not being protected by trade secrets and that perhaps therefore should be more accessible compared to what they de facto are. And so isn't it perhaps a sin of omission that countries or governments do not have flanking measures or supporting legislation or whatever you might call it that would actually provide assistance to challenging the false claims of a trade or being protected by trade secrets when it actually isn't? Shouldn't we be sort of thinking along those lines? And a very, very simplistic analogy is that in the telecom sector, it is usually considered best practice if there's an independent regulator. And so what we usually score in other contexts is ask, does a country have an independent regulator? And if it hasn't, then it gets penalized, right? So the penalty is for if something desirable is not being there. And so should we perhaps be thinking along, a variable or a measure that looks for supporting legislation that challenges these data troughs that are currently being locked up de facto. And if that is not there, then that leads to a penalty point. Sorry for a long question.
No, I think that's an excellent idea. And so what we have a problem. Well, we have two, problems, and I don't, one is the over assertion of trade secret rights, the assertion, the claim that information is protected by trade secret when it actually isn't. And related to that, but depending on the sophistication of the company and how much they're willing to admit, we have the problem of self-help, right, of keeping information secret. So you could have a situation where information is a trade secret. Well, information is not a trade secret, but people assert that it is. That's a problem. And then you can have the problem where it's not a trade secret, and people know it isn't, but then they keep it secret. And they might, in that situation, and this is part of trade secret theory, part of trade secret theory is by having trade secrets law, you actually facilitate the sharing of more information because people are willing to share it in the context of a confidential relationship. If you admit the information is not a trade secret, then the opposite theory probably applies, which is what you're trying to lock it down more. So definitely what you said would address the question of the over assertion of trade secrecy. what we might have to look at also is what countries do to facilitate the sharing of information. And of course, historically, both patents and copyrights were designed, patent and copyright protection were designed to facilitate the diffusion of knowledge. And there's been recent criticism that that purpose has kind of been diminished in the last few decades because of various changes to patent and copyright law. So I think we need to revisit that.
Excellent, excellent. Any other question? Any additional question? I think, Sharon, we may, if you agree, we may tap on your expertise again when we will have established the adjustment in our methodology. But that we can make through a, let's say, a call just between the team as such.
Yeah, I'm grateful for how this project has, facilitated deeper thinking along these lines, because it's really important that we, I'm a firm believer, I always have to preface what I say by saying I'm not against trade secrets. I'm obviously for them. I believe in them. But the problem is that I also know that we need information and knowledge for people to be able to grow and learn and participate in society and be productive members of society. And we need it for trade and we need it for economic development. And so it's like we have to have a balance between protection and not. And so I think the work you're doing is very important, and I wish you great luck with it. And I would be happy to help in the future.
Thank you. Thank you so much, Sharon. Thank you, Professor Sandeen, for being with us today. So this webinar, which is of crucial importance for the way we construct our methodology, for the way we advance also in reflecting on the digital index, trade index, and various parameters. This webinar will be recorded. So for all the audience today, if you missed some point, if you had if you have some questions, then you would refer directly to Professor Sandeen after our recording is published. On the site of the project, which is the site monitored by the European University Institute, the project leader under Martin's guidance. Any other last minute comment, question? In which case, we warmly thank Professor Sandeen. If you want, you can stay with us for a minute and with Martina and I, and we will see how we can construct possibly a follow-up. And we invite in the meantime other participants to disconnect, and we are absolutely enchanted that you could really join us in this public meeting today online.
Thank you.
Professor Galliani, you also wanted to greet Professor Sandeen.
Yes, so first of all, thank you very much, Professor Sandeen. It has been really, really interesting, and I wanted to take this occasion just to announce that a lot has been going on for me. So I will keep, of course, working on this project on digital trade integration, at least until the end of March, April, because I will join the Department of Commerce of the government of the United States in April. So at the mission of the United States in Brussels, and to deal with actually the commercial relations in the field of intellectual property between the United States and the European Union and its member states. So I will keep, of course, as I said, working on this project at least until I officially take functions, as then there will be no possible overlap. But so it will be a pleasure until then, of course, to keep working on this amazing project, and actually very intellectually challenging. I think that it's challenging under every aspect, but certainly trade secrets or undisclosed information, as they are amorphous And as also they change the regulations from country to country is even more challenging than other fields. So a lot of food for thought. Thank you very much.
Thank you, Gabriele, for informing officially all of us. Thank you, Professor Galliani. So you will leave Bocconi, but you will keep many friends. And of course, being at the US mission, serving the US government from Brussels, you may be in contact later on, I suppose, with Professor Sandeen as well. So it's a real pleasure to see that the world is interconnected through various ways and not only to digital trade. So thanks to all of you for your attendance. I should stay a minute perhaps with Martina to see how we go ahead on this, if you agree. And we shall meet and greet very soon and see how we follow up. And then we can't wait for greeting Professor Sandeen at Bocconi, an invitation that has been long delayed with COVID. But we really hope that we are on the right track. We hope. We are still full of hope.
Yes, I can't wait.
Thank you. Thank you.
Thanks a lot again, Professor Sandeen.
All right, take care.
Thank you.